certainly all of us agree that there was income realized and it therefore should be taxable to the investors. But the way that the tax is written, this mandatory repatriation tax, it applies retroactively. So any business that existed from 1986 to the present who earned income over that period of time, an investor's share of that income will be attributed to them to pay taxes on. Now, in the case of the Moores, they apparently invested in the company at the time it was started in 2005, and so they were investors throughout that period. But as I understand it, the way the tax is written, if you were a shareholder in 2017, then potentially all of the income that's attributed to the corporation over the period 1986 to the present would be attributed to you based on your shareholding in 2017. So essentially you have potentially a situation where somebody who might not have been an investor throughout that period would essentially have to pay taxes retroactively on income that was earned by a corporation, but they themselves were not even a shareholder the entire period. And again, even if they were a shareholder the entire period, the question is, can the Congress retroactively impose taxes going back, as long as 40, almost nearly 40 years? I mean, there certainly are cases of retroactivity in the tax code, but generally they're limited to a year or two. So, does this case, and I think actually Justice Kavanaugh raised this point in the oral arguments, can Congress justify going back more than a year or two? And in this case, they went back several decades. What are your thoughts on that, Stephen?
Well, Steve, I certainly agree with you that the due process issues would have been a stronger argument for the Moores. Now, the Moores raised due process issues as well as unrealized income issues, both at the federal district court and the Ninth Circuit. They lost on both of these bases. But the Moores chose only to appeal the unrealized income to the U.S. Supreme Court, leaving behind the due process question. The reason they did that, in my judgment, was they wanted to win on the argument that unreceived or unrealized income cannot be taxed. That was the important issue that would preempt billionaire taxes and upend a lot of our capital taxes. And so I don't think they were particularly interested in the due process issues. Now, they did raise those below, and the standard that the lower courts used, which I think is appropriate, was whether Congress had a legitimate purpose to trying to collect taxes on those earlier years of undistributed profits. And yes, in my judgment, and I think the Ninth Circuit and District Court said so expressly as well, that as the 2017 legislation transitioned our international taxes from a worldwide to a territorial system, a restructuring, all of these accumulated earnings amassing to $3 trillion would have been permanently tax-free if they hadn't been taxed at some point in time. Now, Congress, as an administrative matter, thought the easiest way would be to collect taxes at the time of the transition and not spread the taxes over some future period, which I think your piece suggested. To me, that's Congress's prerogative. That's the way Congress drafts a lot of tax rules, what's known as the so-called cutoff approach. But having said that, the Moores case is not particularly sympathetic. The Congress only reached back for them to 2005, not back to 1986. And so were this the right case to try to strike down on due process considerations, this repatriation tax, the Moores were really not the right vehicle, the right people to be challenging it.